Police have an uncontested right to use force when necessary to apprehend and/or subdue any suspect of a crime. Let's take a look at discretion and the use of force. Police have the right to use lethal force only if they believe that a suspect poses a threat to the officer or others. When their use of force exceeds that which is reasonably necessary to accomplish their lawful purpose, it is defined as excessive force and is unethical and illegal. Under a holding from a Supreme Court case, officers have the right to use reasonable force in any interaction with the public as determined by the facts and circumstances. The FBI reports show that a number of individuals killed by police has been increasing while the crime rate has declined. According to official reports, officer-involved killings averaged in the 400s in the last decade or so. This compares to averages in the 200s in the 1960s and 1970s, and averages of about 350 in the early 1980s and 2000s. There are major efforts underway to obtain better statistics. Some states have pursued legislation to require police departments to report shooting data to a centralized source. Several other organizations, such as the American Bar Association, have announced that they are constructing databases of shootings. The most important thing to know is that the use of force seems to be present in a very small percentage of the total encounters between police and citizens, and excessive force occurs in less than 1% of interactions with the public. Second, research indicates that a small percentage of officers seem to be responsible for a disproportionate percentage of use of force incidents. It is inevitable that police officers will need to use some level of force in response to non-compliant or resisting suspects. In almost all cases, their actions are supported by the law and policy. Cases where officers' use of force meet the definition of a crime are extremely rare. One would expect that most officers shoot only in the situations where they're legally justified. Therefore, there should be few, if any, prosecutions of officers and their use of force. However, some argue that prosecutors are unwilling to pursue charges against officers because of the close working arrangements between prosecutors and police officers, and/or that the police cannot conduct such investigations fairly and objectively. Recently, officers have been more likely to be charged or indicted for shootings or other uses of force that result in serious injury. Civil suits are more likely to be successful than criminal prosecutions. The reason is that the level of proof necessary to show legal liability is lower. Also, suits are often settled by cities before reaching trial. Officers may not be criminally charged, but might still face discipline for violating policy. Recently, the Department of Justice has become more aggressive in investigating and identifying problematic use of force patterns in several cities. More than 20 cities have been a target of a DOJ attention. The federal investigation typically ends with either a judicially approved consent decree or joint memorandums of agreement that detail a range of changes to the department that must be completed. A consent decree is a legal agreement between the Justice Department and a police department whereby the police department agrees to perform specified activities and submit to monitoring to ensure that the department meets the terms to the agreement and avoids lawsuit. Recently, a small set of law enforcement officials have called for new approaches in training and renewed emphasis on how to defuse situations to avoid the use of force. It has been reported that 58 hours of training is given to recruits in the use of firearms and 49 hours in defensive tactics, but only 8 hours in de-escalation techniques. The Police Executive Research Forum, or PERF, comprised of former law enforcement officers, seeks to increase the training emphasis on de-escalation and presented a set of guidelines or principles that included prohibiting firing from a moving car, using de-escalation strategies before resorting to force, abandoning the so-called 21 feet rule that advised shooting a suspect with a knife if he came within 21 feet because the perceived likelihood that the officer could be fatally injured, and administering first and immediate aid in taking the shooting target to the hospital immediately without waiting for an ambulance. Whether it be lethal force, a taser, or physical blows, officers have been given the discretion to employ force that, if performed by citizens, would be illegal. We expect them to use such power wisely, and they have the legal duty to do so. That is, they must make reasonable decisions based on the facts and circumstances of each case.